Thank you. Let me begin by saying how honored I am to be asked to speak at this vitally important conference. I just got to check my watch, so I have an idea of what my timing is. I've been asked to speak in support of certain limits to the word speech, in particular to hate speech, a position that I know is inimical to many Americans, and I'm sure many of you today, who see free speech rights guaranteed by the First Amendment as completely sacrosanct, which is a position that takes the U.S. outside of an international consensus that includes virtually every democracy in the world. It's my proposition that hate speech laws can be an important tool in a multicultural democratic society, and if properly used, subject to necessary procedural safeguards, they can coexist with the exercise of free speech in a democratic society, and that they don't have to pose the same threat of lawfare that libel lawsuits and libel chill poses. It may well be at the end of my speech you'll decide that I'm what David Harris described as one of the useful idiots in propounding this position, but I'm going to put it forward to you because it's important to know that as much of a concern as lawfare is, and I think it's a serious concern, that it's not the only concern, and that we have to understand the limits of this concern as well. We have to, having said that though, it's very clear that hate speech laws, and I'm talking more particularly about Canadian hate speech laws, have to respond to concerns that have arisen, particularly about procedural fairness. Canadian human rights tribunals, for whatever imperfections they have, are not, as we just heard, kangaroo courts. They are, and I'm going to get to that, hopefully I'll have time to do that. What I want to propose to do in my talk is, first of all, offer a brief background to hate speech laws generally, and particularly with reference to Canada, where they are the subject of great debate. And I'd like to address some of the arguments, both traditional and new, in Canada against hate speech laws, in hoping to show that some of the attacks against them are somewhat overblown. That, and as I said, that hate speech laws can be compatible with democracy. If time allows, I'm going to talk about as well the abuses of free speech in order to carry out the same aims as lawfare is intended, and that hate speech laws perhaps can be used to do what we heard earlier, which is to fight fire with fire. That if Islamist preachers who are preaching anti-Semitism aren't being brought before the law, that perhaps one of the answers is to do just that. Let me, with regard to background, when I speak of hate speech, of course, I'm not just speaking of speech, I'm speaking of any expressive activity, whether orally in writing, whether posted to the internet or what have you. And it's this kind of expressive activity that attempts to promote hatred or contempt against particular groups in society, usually but not always vulnerable groups. Hate speech laws are aimed at punishing or preventing such expressive activity, whether the laws are criminal prohibitions or civil remedies such as group defamation laws, human rights statutes, or even immigration and custom laws that try to keep hate propaganda and hate propagandists outside of the country. And I want to first of all distinguish these laws from the laws of blasphemy, which attempt to enforce a particular view of a particular and usually very traditional religious view. And blasphemy laws are meant to protect religions. Hate speech laws are meant to protect people. In the 10 minutes available to me, I have little time to distinguish the various approaches taken in various democracies to hate speech laws, but I'll point out again that virtually every democracy in the world has them, including Canada, the UK, France, Germany, Israel, India, Australia, and New Zealand. And there are a number of international treaties that actually require the signing states, the signatories, to pass laws with regard to hate speech. The International Covenant on Civil and Political Rights, the International Convention on the Elimination of All Forms of Racial Discrimination. These international treaties are an outgrowth of the understanding that emerged from the Holocaust, that Auschwitz wasn't simply imagined in some drunken beer hall meeting of brown shirts, or even at the sober Wannsee conference, but in the pages of Der Stürmer, where Jews were portrayed as vermin and bacillus deserving of extermination. And that words of hate against minorities have to be taken seriously because they can inspire such serious contempt against minorities that they can lead not only to oppression but to genocide, as we've seen in recent years in Rwanda, where the Tutsis were described as cockroaches to be exterminated. In a 2005 Canadian Supreme Court decision dealing with a former Rwandan cabinet minister named Leon Mugesera, who made such an inflammatory speech on national television in the months leading up to the Rwandan genocide, the Canadian High Court found that hate propaganda, particularly when it advocates egregious acts of violence, may constitute a crime against humanity. I'll point out as well that in the Middle East, hate speech is one of the instruments of war. It's an important tool to foment hatred against Israelis and Jews in general, whether it's terrorist groups like Hamas, which refer to the protocols of the Elders of Zion in their very charter, or Hezbollah, which owns a TV station that continually broadcasts shows with blood libels, or television stations in Palestinian-controlled areas that rip off Sesame Street in order to teach children to hate Jews more than they love life. Or even, as we're going to hear from Erwin Kotler, about the ravings of the president of Iran, the genocidal ravings of Ahmadinejad. In Canada, our hate speech laws come from the shadow of the Holocaust and as an outgrowth of concern about a resurgent neo-Nazism in the 60s when these laws were first considered. And what happened is Canadian governments decided, both provincially and federally, to make changes to the criminal code to outlaw certain types of the most egregious hate speech, incitement to genocide, incitement to hatred, and human rights laws, which were concerned with equity and discrimination issues, whose jurisdiction was expanded to include conduct that exposes people to hatred and contempt. The themes of these laws include a concern with harm, not offense that people take to critical expressions. You have to rise to a very, very high level, according to a number of cases, to reach the level of hate, including, in one case that talked about the requirement of showing that members of a targeted group are devoid of any redeeming qualities or innately evil, and even that nothing but their extirpation from society will protect society from them. Mark Stein's article, for example, which posited a Muslim time bomb in Europe, was found by a human rights tribunal not to meet that standard. And so I'm going to go quickly, in the 2 minutes available to me, to talk about some of the criticisms, and maybe in the questioning I'll have more time. I'm going to talk only about the argument that you can't get a fair hearing in human rights tribunals, that they're kangaroo courts, that they're monkey trials, and what have you. And I've appeared in many human rights tribunals. I've been on both sides, frankly. I've appeared in favor of the prosecution of guys like Ernst Zundel, one of the foremost Holocaust deniers, and B'nai B'rith has been the subject of a lawfare human rights complaint. So I've seen both sides of these things. But what I can say is, first of all, we hear a lot about Levant and Stein, but I'm going to point out to you that the Stein case is the only lawfare kind of case, and it was a lawfare kind of case, that went to a tribunal. But there was a full hearing, and it only went to a tribunal, by the way, because in British Columbia, there are 3 cases brought at the same time, and British Columbia is the only one of those jurisdictions that doesn't have a commission that can screen out these kinds of cases. But at the end of the day, here's what the tribunal said, and it's in the materials. At paragraph 159 of a case called El Masri, who is the Islamist who brought the case, versus Rogers, who owns the magazine. The article, Why the Future Belongs to Islam, with all its inaccuracies and hyperbole, has resulted in political debate which, in our view, Section 7.1, the operative section, was never intended to suppress. Can I just finish the sentence?
Yes, please.
In fact, as the evidence in this case amply demonstrate, the debate has not been suppressed, and the concerns about the impact of hate speech silencing a minority have not been borne out. In fact, it talked about how there was a very useful public debate that was caused by this case. Thank you.